Most lawyers guess at what a TBI case is worth. I stopped guessing 100 cases ago. I spent 15 years practicing one area of law, TBI litigation. I spent the last 7 writing the book. It's called The Ernst Way, the definitive guide to TBI litigation. Every case I tried, every depo I sat through, every witness at trial, what worked and what didn't. 15 years of depth down to a single question. How do you prove what a brain injury costs a human life?
I have deposed the defense neurologist, neurosurgeon, defense neurosurgeon, who basically says she has the mildest of mild TBIs, but gives it to her. I have the neuropsych next week, their neuropsych next week. My neuropsych has been deposed and given it. My neuropsych says, yeah, she's got lots of
What's their neuropsych say?
Their neuropsych says she's a big fat faker. I'm a malingerer.
He says malingerer?
Yeah.
Okay.
I tried, having done this a couple of times, what I tried to get the defense to agree to was let's have an independent, agreed upon neuropsych take the test, and then we'll give the raw data to each of our experts. Like we can all be reasonable about this. And they said no, so I had my neuropsych go first. They took neuropsych 18 days later. So they so my neuropsych did the testing over 2 days, half day each, because my gal gets tired easily. I mean, all the symptoms, she is exhausted, she has to take a nap, all that stuff. The depositions, same way, half day. Their neuropsych made her do it in 1 day.
What is the biggest problem that you see from the case right now? And then I'm gonna work through a bunch.
Okay, biggest problem, I mean, we've got that they say that if there was a TBI, it should have been over in 6 weeks. But the biggest problem I think I have, we're getting ready to go to trial for 3 weeks. And she's good looking, she's fit, and I don't think she's going to make it sitting next to me for 3 weeks, full days.
These are all solvable. And again, it's pattern recognition. I've looked at so many of these, it's like, oh, this is what you do. So first is the GCS. When they say 15 and she was unresponsive, ask hypothetical questions to the defense expert. If she was slumped over, unresponsive for a minute, what would her GCS have been? They're gonna give you a number or they're gonna dodge the question. Ask that question a bunch of times over, and they'll then dodge from, well, GCS is taken as the highest score in the first 24 hours, because that's what some of the papers say. And just say, I'm not asking about that. I want to know if she's slumped over and unresponsive, what would her GCS have been? And if he doesn't give you an answer, then you have your expert come back and say, hey, the GCS would have been 13 or 12 or whatever. So that's number one. GCS is a snapshot, and it was invented before MRIs. MRIs were invented in 1974. GCS was before that. And so there's a really fun cross out there that I think I give away, or I think I've written down if you want to ask for it. Basically you say, hey, are you using a score invented before MRIs to say that this isn't that big of a deal? And it's 5 or 10 questions, but that's the gist of it. Because if GCS is the snapshot of the individual incident at the time of the incident, you have data from another 3 or 4 years. They're no longer a statistic. They are actual individual with all this data that you can use. So that's number one. Number two, talking about concussions. If she had concussions before the incident, if someone has brain injuries before they have the brain injury that's the incident, they are more susceptible. You need the eggshell plaintiff in there. You need aren't they statistically significantly more likely to have long-term complicating issues, and they're more likely to develop early onset neurological disorders like dementia. And so the fact is, you just be like, yeah, of course she had these 3 concussions before, and look, that's why she's so hurt, and that's why none of those statistics that you're talking about apply. So take your worst fact and make it a really strong fact. They're going to talk about disability. You do not want to get in a disability rating fight, because they will use standards from whatever state you're in to say, oh, she's not disabled, or she's still working with accommodations, therefore she doesn't have any form of disability. And there's a fun cross I actually was learning from Nigel or Danielle. Somebody this weekend was telling me, like, oh, this is cool cross. Can you have a car with a only partial flat tire. Does it still drive if it's 25% disabled? Like, what do what do you think is more important, your car or your body with your brain that has a disability? And so like very quick reframing, and they'll be like, oh, disability, disability, and be like, we're not talking about disability. We're talking about long-term damages, and then talk about what the things are in the verdict line. Neurosurgeon, hey, isn't it true, doctor, that you treat inoperable cancer and cancer where you're taking part of people's skull off, and could be very graphic about how he's taking people's brains apart? You know, where you have to cut through the skull, and you have to drain the blood, and you have to put them, oh wait, they're still awake, and you have to poke here and say, do you feel that? Do you feel not that? You do brain surgery, right, doctor? So your entire opinion is she doesn't need brain surgery? Did we allege she needs brain surgery? Is there any plaintiff expert that says she needs brain surgery? How much did they pay you? 20 grand? Why are you here? We didn't allege that. Just handle that guy or girl. Malingerer. Malingering was a paper that came out in 2016 that basically says you should never use the term malingering. All neuropsychs that are good neuropsychs are aware of this. If they use the term malingering, the cross on them is, and you got to be really specific, because they will try and say, oh, the tests tell me that they're malingering. No big deal. The tests tell me that they're malingering, or they're not putting forth good effort. Break it up and say, you say not forth good effort. Malingering is an intent diagnosis. And they'll try and say, well, statistically, if you have a lawsuit, that can be a thing for secondary gain. Tell me a single fact that shows that their intent is to deceive. Are they lying? Do you believe they're a liar? Why do you believe they're a liar? And they'll say, well, the test scores tell so. The test scores say low effort. They don't say lying, do they? Is there any test that shows lying? Well, they show that they put forth good effort. And if you have a bunch of not good effort, doesn't that just show they're valid or invalid? Especially if they have a bunch of other issues, because pain causes a bunch of problems. So go after malingering super hard as it's a bullshit thing. And then if you really want to hit them with the paper, I'd save the paper till trial and have your expert be like, if anyone used the word after malingering in 2016, they haven't read a paper in 10 years. Because no neuropsych should ever diagnose malingering because there's no intent. Test effect. They're going to say, hey, you know, however many weeks later, your guy got a better score because of the whole thing of test effect. Who picked the tests? Could you pick different tests? Could you know that our neuropsych was going in and then your neuropsych was going? You're going to have to find out how a fact that shows that they knew they were getting raw data from your guy, or whatever the fact is that they knew, because he can pick whatever tests he wants, or depending on the stipulation he does, he could give different batteries or different effects or different things, so the test effect shouldn't be there. And it depends on the batteries. There's some that you're going to end up with that anyway, but that would be the best attempt for how to do that. Better in 6 weeks. That's something that we deal with in almost every TBI trial that isn't, you know, they're missing part of their skull, or their brain is got a really significant problem and they had to do brain surgery. The 6-week thing is a really strong cross out there that when did you evaluate them? Did they have signs and symptoms? Of those signs and symptoms, was one of the things that you considered the fact that they were truthful? Did you think they were truthful? Did you, when you do the exam, you want to make sure when they did the exam if it was before or after their battery, because they'll say, well, I thought they were not truthful because of the battery. If they did the intake beforehand, did you believe them before you knew the results of the test? Because they'll say, yeah, I believe them. You're supposed to always believe the client in medicine, and so when they report something to you, you're supposed to believe it. If, doctor, you tested them 2 years after the date of the incident, and they still had symptoms, and you didn't have a reason to not believe them at the time you evaluated them, why do you believe they're better after 6 weeks? Did they have the symptoms 5 weeks? Did they have the symptoms 7 weeks? Did they have the symptoms 12 weeks? And then run it all out, and you can make a cool graphic for trial of how many different times they had the symptoms and all the records. And then he gets to the report and he says, oh, these should have been better after 6 weeks. And the dude just looks like a goofball. We regularly will have the client at trial like 1 or 2 days. Like and the way we handle that is we'll ask in voir dire, would it offend anybody if the client, for medical reasons or work reasons or whatever the reason is, isn't present the whole time? And the jury's like, no, we have no problem with that. You really need to make sure you remember to ask it, because it's the only time you can ask it. And if you don't do it and then they're gone the whole time, the defense attacks you on it. I also think there's a motion in limine that you can file that the presence or non-presence of the client at trial is irrelevant, because it's not facts before the jury that came off the jury box. and it's basically them arguing facts outside of what actually occurred in the courtroom. And I think you can say, hey, it's not relevant. And the defense will be like, well, it's relevant if he's here or not. And you say, well, no one said that off the jury stand. And you should file that motion after the trial's over and right before closing, so they can't have an expert be like, yeah, the client should have been here the whole time, and fix it.
Let's raise the bar together. I'm Taylor Ernst. Thanks for watching.